It is Saturday morning, so it must be legal AF and unprecedented about the Supreme Court. We're excited over here for the Supreme Court reopening, not because we're expecting amazingly good decisions, but just because their court is back in session. You might have thought, well, haven't they been in session this whole time? No, they've been working on their emergency docket and issuing shadow opinions. But now, on the first Monday of October, which is coming right up off the weekend, they're going to be holding their new term, the 25-26 term. And we've got an inkling of what's going to be happening, of course, that we've been focused on. And so let's bring in Dina Doll.
Hello.
Hello. Let's jump into all things unprecedented. Where do you want to go first? We'll spin the wheel. Where do you want it to go? I
want to go to Hawaii, literally and figuratively.
I'd like to go to Hawaii. That sounds great. But I have a feeling I'm not going to like it when I get there in this segment. What's it all about?
Well, no, we're going to like what Hawaii is like. We're just not going to like what the Supreme Court is going to do about Hawaii. But basically, the Supreme Court just decided to take another Second Amendment case. And frankly, all the discussion around the murder of Charlie Kirk, there is not enough around gun control. I wish, honestly, we would be hearing more about that, because that is obviously a fundamental problem in this country. So Hawaii had a few laws to try to protect its citizens there. One of the laws said that you could not bring your concealed weapon into a private property, a restaurant, a bar, et cetera, unless that property owner expressly consented to it. Very reasonable, right, Popok? It seems very reasonable, especially it's like somebody else's private property, frankly, right? So, of course, they sued over this and that this infringes on the Second Amendment. And of course, we're going into the 2022 decision, the New York State Rifle versus Pistol Association, that really changed the landscape. And just for a really quick recap about the gun laws and how they have transpired with the Supreme Court. 2008 Heller decision written by Scalia, Justice Scalia, was the first time the Supreme Court enshrined a personal right to carry a gun. Before that, the Supreme Court never had it. So for anybody who says, we look to, historical context of how it's written. Well, we've never in this country ever had a personal right to bear arms, except until the 2008 decision. And then the 2022 decision carried that out to self-defense outside the home and specifically said courts in deciding laws have to look at historical precedent. There are two different cases, actually, that Hawaii decided around their own gun rights laws. The one that the Supreme Court just decided to take is called Wolford versus Lopez, and that has to do with this concealed weapons with private property. But there were a few quotes from another case also decided by the state Supreme Court there that were so amazing. I just had to quote them because we do not hear enough good words about gun control. And their justification for saying that their own state, they have a Second Amendment in their own state constitution that resembles the United States Constitution. And they said that they interpreted their own state constitution not as having this, personal right to bear arms, but having a right to be able to defend the state as a militia, right? And they said, quote, "The spirit of aloha clashes with a federally mandated lifestyle that lets citizens walk around with deadly weapons during day-to-day activities." And frankly, I 1,000% agree with them. The spirit of aloha 100% clashes with the American insanity, frankly, around guns right now. And they went on to say that their state's rights to have a militia it was not someone packing a musket to the wig maker just in case. So I wish our own United States Supreme Court would be more like the Hawaii State Supreme Court.
Yeah, the problem is they're not, and they don't care about muskets versus AR-15s. And this case that they've taken is a bad sign. If I had a guess in the outcome, it's going to be that restaurants and bars cannot stop people from having a weapon in their restaurant and bar. They're going to go back and say, in the old-timey times during the saloons when the doors blew open and the guy came in with the guns, he grabbed a drink at the bar, and they'll you'll get like Alito citing to some John Wayne movie as if it was a documentary, right? I could write it now.
I know. And so to counteract the depressingness of that, I want to remind us of the spirit of aloha, because, at some point this has to change, right? This has to change. It is the evil rot, frankly, of this country, that we are accepting school shootings, accepting of children being shot at school on an everyday basis. The fact that, personally, I think the fact that we have come to accept that there is nothing we won't accept as a society, because to me, accepting that level of evil, where do you go from there? So,
we'll stop right there. That's the problem with the MAGA administration, with the Trump administration. They want you to believe that a few peaceful protesters on hashish brownies in Portland, Oregon, deserve to have the $10 million worth of military firepower aimed at them, and try to crush First Amendment expression in and around a detention center. Nobody's dying there. They had, 20 arrests since, all peaceful protesters. But no, we have to go in and declare a war against states and all of that, while every day hundreds of Americans are at risk or die in gun violence, including in schools, churches, bowling alleys, supermarkets, and the like. And they turn a blind eye to that. But one of their fallen heroes has one bullet fired at him that hits, and it's because they have to distract from the Second Amendment, and they have to distract from that. Then they have to turn towards some other one, which is radical liberal thought never got anybody killed.
Yeah.
Radical democratic voices killed X, Y, and Z, and yet ignore the hundreds of children who have been thousands who have been slaughtered.
Yeah, and I almost wish that we didn't have our a rebuttal be, oh no, but the right has bad rhetoric, because it's not about anybody's rhetoric. You can never eliminate, in a country of hundreds of millions of people, from 1 or 2 or 10 people wanting to pick up a gun that was supposed to be used in war and shooting it at people. It's not really about the rhetoric across the board. It's about the guns.
And Dina, I think now is a perfect time to really do a deep dive into the United States Supreme Court. And I don't want to say a historical perspective, but certainly a examination at the molecular level of the Roberts Court. And what is going on with the Roberts Court? I see all these headlines with articles around right now. The Roberts Court has made a king out of Donald Trump, but I can't think of anybody better of our roster of colleagues than Lisa Graves, who's with us over here on Court Accountability Action, True North Research. She wrote a book, and you're going to love the title, Dina. It's not unprecedented, but it's darn close. It's without precedent. And let me give you the full title of this, and we'll get it up on the screen. How Chief Justice Roberts and his accomplices, we'll talk about that, rewrote the Constitution and dismantled our rights. Well, that sums it up right there on the cover. It's out in hard copy and in electronic versions on Amazon. But more importantly, we got Lisa Graves with us. Hi, Lisa.
Hey, thank you so much for having me on.
Of course. Everybody knows you from your amazing investigative work and commentary here on the Legal AF YouTube channel. For those that are interested and maybe don't recognize her, got a great playlist for Court Accountability Action. Lots of Lisa Graves hot takes, and guest appearances from some people from your world who bring in some great interviews here and really just class the place up.
Oh, well, it's a joy to be on with you, and I'll do duos with Dina, and I'm really happy to be part of Legal AF.
That's another thing I forgot. You guys do your duos, and so whereas a lot of people, like when you say, "What'd you do over your summer vacation?" People, "Oh, I read a book." You wrote a book.
It's true. It was it was the last 2 weeks of August and every weekend at the end of last year. So it was a labor of love.
So let's reel them in. Let's reel our audience in. I think we've already got them hooked. What is the premise of your book, and why did you decide that it needed to be on people's shelves? What was missing on people's bookcases?
Well, I think a lot of people have given John Roberts the benefit of the doubt based on his initial introduction to them during the hearings on his nomination to the Supreme Court. And in that moment, he defined himself, depicted himself as a fair umpire who would only call balls and strikes. I was the chief counsel for nominations for the Senate Judiciary Committee during the first George W. Bush administration, and I had tried to keep him along with other folks who were aligned with me, to keep him from getting on the DC Circuit as a stepping stone to the Supreme Court. But he was confirmed to the Supreme Court. And back then, I feared that he would be a destructive force for our rights. And the last 20 years have proven so. So I wrote the book because I really want to pierce that myth. I want people to understand who John Roberts is, what his longtime agenda has been for rolling back our rights, and also just the cloud of corruption that has surrounded the court, and the roots of that in some ways with his what he did to get confirmed, to get chosen for this spot, and to get on the Supreme Court.
What was it about? I mean, you were a pretty early adopter of resistance against John Roberts and saw things that others did not see, and unfortunately are being proven correct. Sounds like you were a close follower of his career, his body of work, his writings from maybe the White House forward. What was it about John Roberts that you didn't even want to see on the lower level court of appeal, the appellate court right below that, let alone to become the Chief Justice of the United States?
Well, to me, I could see quite clearly that he was a Reagan revolutionary, that he had been devoted to the most extreme parts of the agenda of the Republican Party from the beginning of his legal career. And I used to joke back before he was nominated to the Supreme Court that the best thing that ever happened to John Roberts was that Bill Clinton won, because then he got about a decade to, pal around Washington and try to make inroads with some Democrats and with some progressive groups to try to, if he had a whole history of work where you could see that he had been anti-environmental regulation, for example, he could do an oral argument with an environmental group, pretend to be Scalia or Rehnquist, and then get their support, or maybe get them to be back off a little in opposing him. So it seemed to me that I used to say that he had a talking points resume, where he had this whole history of a devotion to these extreme ideas, but he would do one thing so that there'd be a talking point to counter what your natural presumption would be about him. And he was also someone who had a reputation for being charming, and so perhaps persuasive if he were to get that power. And so I said to my colleagues that when he was ultimately moved through to the DC Circuit after the Republicans took control of the Senate during the 2002 midterms, I said that he was going to be their guy for the Supreme Court if he were confirmed. And so I asked my boss, and then we asked Senator Reid if we could have John Roberts not have a recorded vote, so that the members were not tied into having supported him, so they'd have some flexibility to oppose him if he were nominated to the Supreme Court, which was my prediction. And in fact, he was.
Amazing. Dina?
Yeah, I mean, when we did Legal AF together not that long ago, you talked about moral corruption, which I think is so interesting, because obviously we've talked a lot about the financial corruption, frankly, with the Supreme Court, but the moral corruption, that really came from your research in this book too. I mean, what do you see, and especially in this moment, like, what does that mean? And what did you kind of call out in your book about that?
Well, one of the things that I looked at was there was just one set of questions from Senator Feingold to Roberts about the fact that he had presided over a key case for the Bush administration, or basically for the Bush administration, when he was a judge on the DC Circuit. That case was the signature effort by Dick Cheney and George W. Bush and Alberto Gonzalez to step aside from the Geneva Conventions. So Roberts began interviewing for a potential job on the Supreme Court while he was presiding over that case. And during the hearings on his nomination, he basically used the ethics code as a shield to answering any questions about that conflict. But it's just black letter law across the country that if you were a judge presiding over, a civil case or a criminal case, but if you were presiding over a case and you were interviewing for a job with one of the parties, you would have to disclose that and recuse. But if John Roberts had disclosed that, he probably wouldn't have gotten the job. And if he had recused himself, he probably wouldn't have gotten the job. And then he ruled in favor of the Bush administration after more than 100 days of interviews with the top officials who orchestrated that policy. Now, of course, I'm not saying that they asked him how he would rule. It was implied. He ruled for the Bush administration. And just a few days later, that's when Bush named him to the U.S. Supreme Court. And the other part of that story is the other finalist for that job was Judge Michael Luttig. And so John Roberts, in my view, sidestepped those ethics rules from the outset due to his ambition for this position, ruled in favor of the Bush administration, expanded the idea of presidential power to defy our obligations under the Geneva Conventions and more. Ultimately, the U.S. Supreme Court reversed that ruling, and Congress passed the Military Commissions Act to provide the statutory basis for that particular treatment of the individuals in that case. But the fact is that that's the origin story in a way for John Roberts. He was willing to sidestep that baseline rule that you just cannot be interviewing for a job with a party to a case. And that's the beginning.
Yeah.
Well, it kind of sums up why the courts seems to have a allergy to ethics and conflict and disclosures, because the tone is set from the top. The book's title, it was of course intriguing, the subtitle, How Chief Justice Roberts and His Accomplices Rewrote the Constitution and Dismantled Our Rights. Can you tell our audience is going to buy the book? Trust me.
Please.
you need to support authors and investigative reporters and journalists like Lisa Graves. And the way you do that, people say, how can we support people? This is how you do it. This is you buy the book Kindle or electronically or Amazon like I did, and you keep the receipt. And that's how you support somebody like Lisa Graves so that she writes her next one. But summarize your thesis for our audience about what Chief Justice Roberts and his quote unquote accomplices have done to rewrite the Constitution.
Well, the fact is that John Roberts wasn't chosen to be fair. He was chosen because they thought that he was a ringer, that he would be a sure vote for this Reagan revolution, this right-wing revolution, to enact it through the Supreme Court. And you can see that because the Federalist Society had a couple years earlier started this mantra, no more suitors. But they didn't apply that to John Roberts. What was the sin of David Souter? It was that he was a fair judge. He followed legal precedents. He wasn't an ideologue. So Roberts is the first victory in that No More Suitors campaign. And he's also the first person appointed to the U.S. Supreme Court, backed by this sort of dark money machine that was trying to capture the court. And so under John Roberts, we now have him plus 5 other justices, which you've called the MAGA 6. And I think that that's an apt label. You have six justices on that court who are basically determined to overturn legal precedents that Americans rely on that protect our rights. That, of course, includes the Dobbs decision overturning Roe versus Wade. It includes a host of other decisions by this court, including decisions earlier this year and this summer through the shadow docket. This court, in my view, is out of control, and it is drunk with power in its zeal to basically aid Donald Trump, as we saw last summer with that unprecedented grant of immunity from criminal prosecution for Donald Trump that paved his way back into power, and all the ways the court has been blocking and stopping and overturning lower court rulings to stop the Trumpian dictates that really transgress not just the Constitution, but Constitution, statutes, regulations, rules, contracts, just to help empower Trump further. And so I'm really hoping that people read the book, understand how we got here, understand the role that John Roberts has played, reject this myth of him as the fair umpire, and then come together to support court reform and the restoration of our rights.
Absolutely. I was going to say that this last month has probably been very bittersweet for you, because you would have loved to have written about the pocket rescission, $4 billion, basically taking away from Congress the power of the purse, the Supreme Court giving it to Donald Trump, allowing him under, he reigns supreme in foreign policy, so he gets to cut out $4 billion in aid. Sorry. And then the Fourth Amendment being completely, I would have thought that if they were going to destroy the Fourth Amendment, and search and seizure and all of that. They would have had the courtesy of doing it in a proper opinion and not take it in the back and shoot it with a 1-paragraph emergency docket ruling, right?
Mhm.
Yeah.
Absolutely. Absolutely. Lisa, thank you so much. I've already bought my book. Did it on Amazon. Reviews are huge too. I know supporting of buying a book, but I know people who've written books before, and a review on Amazon like really helps its traction too, because we want to do everything we can to help you, because frankly, people are telling the truth. And if it's not what Trump and MAGA want to hear, we see what's happening to them. And so, anything we can do to support you, Lisa, we need to hear everything that you have to say. It's a fascinating book.
Let me go back to one point then, because we always like to leave our audience hopeful. You talked about court reform, and you said hopefully people come together once we rip the veneer off, right? Rip the mask off the court and call it out for what it is, not the veneer that it puts on its decisions. Oh, we're not ruling on the substance of a matter. We're just doing procedural. We haven't ruled yet. And then excoriating judges like Judge, of all people, Judge Young, he of the recent 161-page, my favorite decision of all time. But at the time saying, Gorsuch in his recent concurrence in the NIH case, telling him, you didn't follow the precedent of our 1-paragraph shadow docket ruling. And he's like, that was the precedent, with no radio, no gravamen, no facts, no. If you want us to follow something, you better write an effing opinion. That's my paraphrase. So what is the court reform that you think could happen? Is it we expand the court to 15? What is it that solves the problem that you've identified?
Well, it's a multifaceted solution, because it is a multifaceted problem. And I describe a number of those options in the epilogue, and then we'll be expanding on ways people can plug into those reforms. Certainly term limits are part of it. I personally have been in favor of a 15-member court. Why go for 2 or 3? I mean, why negotiate against yourself? Just expand the court and try to undo the damage that this court has done. But there are a lot of other things that need to happen to reform the ethical, just horrible ethical non-standards of this court. Not just what Thomas has been up to with these lavish gifts, but more like who's paying their spouses, who's actually feathering their nests. We don't know who the clients are and whether they've got conflicts, and we do know in some instances that they're in fact having conflicts. So there's a lot of reforms we need to do, but we have to recognize, obviously, with this Congress and this president, that no good legislation can pass right now. But we have to build the momentum for restoring our rights, and that includes court reform, or this court will continue to try to take away our rights.
I have your next book title, Project 2028.
Yes.
With a big chapter that you write about federal court reform, and then we put you in charge of that when we regain power, right?
Yep.
Well, I'm happy to help in any way. But I appreciate the endorsement on that. And the fact is there's so many things that we could do coming together, and to call for that kind of reform and insist on it, because this isn't just some sort of policy fight. This is a moral imperative about our rights, about our freedoms as Americans, and whether we're going to cede power to a court that has been stacked and packed to not act like a court, to not act like fair judges, but to act like political operatives aiding the party that appointed them. So we have got to change. We've got to change things in significant and bold ways in order to protect our rights and protect our future.
Yeah, look, it's not just the book. The book is fantastic. Everybody needs to read it. But the great news is this particular author is a living, breathing author and commentator and evaluator here on Legal AF, on Court Accountability Actions playlist. And if you want to know more about how Kavanaugh, Gorsuch, Amy Coney Barrett all got on the court and who paid for it, you're going to want to follow everything that Lisa Graves does here in her own writing, on her own. So you have a good Substack. What's your Substack?
It's Grave Injustice. Yep.
Of course, there it is. But this is Court Accountability Action's mission is to expose corruption in the federal court system all the way up to the United States Supreme Court. That's why this is a perfect book and companion for that. Lisa Graves, Without Precedent: How Chief Justice Roberts and his accomplices rewrote the Constitution and dismantled our rights. It's in bookstores near you. It's on. I will put up the screen. It's on Amazon. It's in the notes below to make it easy on you. And I think it's a must-have for the legal AF community to have this up on their shelf. Lisa, always, you're a dear friend. Always a pleasure. You've been a huge supporter of everything that we've done here on Legal AF. You and Dina were one of the first 2 contributors that came on when we were like, we got 25,000, we got 10,000 subscribers, and now look at us. We're going to hit 1 million, hopefully, likely before the new year. And a lot of it is because of you and Dina and Alex and the people at Court Accountability Action.
And you, Popok, seriously, the team that you've assembled and your leadership every single day, hour by hour, it really is an honor to be part of this effort to really inform people, excite people, and help make a real difference.
I am when I look at the landing page for the YouTube channel, and I see the playlist and the people that are here with us, it does fill me with a lot of pride.
Yeah, you have built quite a bit in less than a year. We're coming almost right there, almost close to it. But no, it's so incredible.
No, we just passed the year, September 17th.
There you go. I knew it was right around here.
Yeah.
And thank you, Lisa, for being such a strong advocate for the court reform. It's desperately needed, and for coming on. And always enjoy. We'll do more duets on this and other topics.
All right. Thank you. Here on Unprecedented, we have Lisa Graves with her brand new book. Thanks for joining us, Lisa. It's always so great to have one of our own who the audience adores and knows well and can trust about their analysis, write this fantastic book like Lisa Graves just did about the Roberts Court, really exposing. It's hard to believe the guy's been on the bench for so long, and we're talking about exposés, but doing a real expose about John Roberts and why he can't be trusted. I don't think anybody's written that story, and I can't think of anybody better to write it than Lisa Graves. So glad that she was on here with us. And speaking of the Roberts Court, which we do every week on Unprecedented, we've got this, Donald Trump's finally gotten around after having been blocked by, today or as we're coming on the air, the First Circuit Court of Appeals in over 100-page decision. Nothing says something is very simple like 100 pages. Said it is basically beyond doubt, beyond peradventure, as we like to say in the law, that the Donald Trump cannot, and no president can, by an executive order, change the meaning or the words of the 14th Amendment, giving birthright citizenship to people. If you're born in America on U.S. soil, regardless of the status of your parents, you are a U.S. citizen. You may not like it. You might think it's bad policy, but it's a bad policy that's baked into our U.S. Constitution. And if you don't like it, then go get another amendment. See, this is the thing about the Constitution. And the Atlantic just did a great article about this. The Constitution is somewhere between, as far as our framers were concerned, the dead piece of paper that Antonin Scalia declared it to be, and the living, breathing document that we sort of shorthand it when we refer to it. It's not trapped in amber, but it's not, our framers likely wanted us to follow it as best we could. However, left open the door for it to become a more modern document through amendment. State constitutions get amended all the time. It's been several thousand state amendments, while not one amendment. There's been 2,000 constitutional amendments proposed in the last 50 years, and not one has gotten through in the U.S. Right. So we have abandoned what the circuit breaker that the framers gave us to make the document comply with our morals and traditions, which is why we're giving so much power and ceding so much power to the Supreme Court. 9 people to tell me what something means. If we don't like it, we should be using the power of the amendment. And if they don't like it, although I don't think they have the votes for this, let them go out and get 2/3 of the state and 2/3 of the House and the Senate, whatever it's supposed to be, to get an amendment off the ground or call for a constitutional convention. I think they'll be shocked with how people reject their MAGA right-wing extremism. And I think that's why they don't do it. They try to do it. They try to cheat. Oh, we'll do an executive order and then, see if we can get the votes at the Supreme Court. So First Circuit today said no, joining about 3 other courts that have also blocked. That's why nobody's been denied citizenship since March or April. But now Donald Trump's like, screw it, let's get it up to the United States Supreme Court. So what's going on there?
So basically, Sauer is formally asking the Supreme Court to step in and declare birthright citizenship to only apply to children of people who were either citizens or have some sort of, like, I guess you could say, more lawful residence. And so, we were sidestepping this before. They were asking more for the universal injunctions in the spring. We were wondering if the Supreme Court was going to touch on the birthright citizenship issue. They did not. They are asking the Supreme Court to take this case. We don't know yet if the Supreme Court is going to take this case. If they say yes, that is a bad sign, because this is very settled law. This is the case coming out of DC. It's Trump versus Barber. And Sauer had an 85-page petition asking for cert, asking for review. He really is trying to say that the one Supreme Court precedent that really is on point here is Wong Kim Ark. And that was the one that allowed the child of Chinese immigrants to be a citizen. According to his petition, this is what Sauer kind of tries to say, is that they mention in the opinion, in the Supreme Court opinion, that his parents were domiciled, that they have some sort of permanent domicile. So Sauer's trying to say that had some sort of legal residency, and that so that the 14th Amendment shouldn't apply to somebody who was here undocumented or somehow was here temporarily. And he says in that Supreme Court opinion that appeared 20 times. And I've always thought, and we talked about on the show, that this was the argument they were going to make. It's really the only crack you could say, because they mentioned that. It's not part of their finding. They don't say in that Supreme Court opinion that he is entitled to citizenship because his parents were lawful residents. But they just mentioned that. But interestingly, right after Sauer mentions that, then he goes into his next paragraph. And kind of to your point, how they talk about the history and it's locked in and it's not a living, breathing document. We've seen so many times where they cherry pick their judicial philosophies to try to get the outcome that they want. And this is a perfect example, because then he says in his very next thing that basically after the adoption of the 14th Amendment, he says, the mistaken view that birth on U.S. territory confers citizenship on anyone subject to the regulatory reach of U.S. law became pervasive with destructive consequences. He is admitting that was the universal understanding and belief of the 14th Amendment. I mean, he literally just says there, after this was adopted, it was a pervasive belief. So according to their let's look at the historical significance. What did people at the time think of the document? You would be done right there. You would say the plain language of the text says everybody, doesn't specify if you were a child of somebody here lawfully or not. And also, that is how everybody at that time interpreted it. But anyway, because they don't always have their judicial philosophies, they don't stick with their principles, let's say, he's asking them to take the case and overturn not only Supreme Court precedent, but how the Congress and American people and presidents in the past and Supreme Courts in the past have interpreted the 14th Amendment consistently since it was passed.
You got 4 or 5 different lower court, appellate courts who've all said this is not this is not hard. This is the easiest thing. I mean, it started with Judge Kofenor up in Seattle 20 days into the administration, who issued the first temporary restraining order. So he's had so many injunctions, Trump, and restraining orders. It's hard to remember the first one, but I remember the first. You always remember your first. And I remember it's Judge Kofenor in Seattle. And he said, this is the easiest decision. He said it's the most blatantly unconstitutional position I've ever seen taken in my courtroom in 40 years. He's a senior status judge. We talk a lot about senior status judges here. They're really doing God's work. They're not retiring, and they're holding on by their fingertips, by their fingernails, and staying in their position, because if the moment although when they go to senior status, there normally is a ability to appoint a new federal judge who's not 70, but they're holding on to continue to get cases and to continue to shape jurisprudence and to fight against Donald Trump. So you got Judge Coffenor, who first struck down birthright citizenship 10, 20 days into the administration back in January. You got Judge Breyer up in San Francisco, who took 80 years old, senior status, who got the Posse Comitatus case and ruled in favor of California about Donald Trump abusing Posse Comitatus. You got Judge Young, Reagan appointee in his 80s in the Massachusetts, who just issued that, again, eye-poppingly eloquent decision about for the First Amendment, taking on Donald Trump in spades in 160 pages. Senior status judge, Reagan appointee. Then you got Judge, and this is just like in the last few weeks. And then you got Judge. It'll come to me in a minute as I'm telling the story. In D.C., it's Judge Lamperth, who came out against the dismembering of Voice of America with Carrie Lake and Donald Trump, and writing a scathing opinion about that. Because I think a part of it is they're not scared of Donald Trump, right? They're 80 plus years old. They're senior status. There's nothing that he can, and I think they really feel like they're holding the lamp of liberty for America. Don't you?
Yeah, no, absolutely. Their years of experience, and just Breyer and his case and his opinion have just been amazing. And yeah, no, we're grateful for everybody who's kind of willing to be of service in this time. It's not easy to be a public servant at any level right now, frankly.
Yeah. Well, somebody that's doing pretty well at staying in as a public servant is Lisa Cook on the Board of Governors. I thought people by now probably know the ruling, which is or the non-ruling ruling, which is pump the brakes on firing her for the Board of Governors. We got more work to do here at the court. Get your briefs in January. Let's all get together and do what we call have a conversation. And by that, I mean an oral argument, and then we'll get around to it. That's the headline. But what did you make of the fact that Trump didn't have 5 votes to right now fire her? How did you interpret that?
I think it's a win, right? And kind of what we were talking about on a few episodes ago. It's the one area the Supreme Court is willing to protect is businesses. And this is the most business opinion you can get. It would be just so incredibly destructive for our financial markets. And the Supreme Court knows that. And so I'm always glad to, honestly, even if it's like breadcrumbs with the Supreme Court. I'm glad they did schedule an oral argument. It's something we can all see. We're going to have it on Legal AF. You and I will talk about it. We need this kind of transparency. We do need conversations. We need it for more, frankly, decisions. But even if it just has to be their pro decisions, fine. So, yeah.
So we've reached the end of another unprecedented. This one, the last one, before the brand new term opens on Monday, for the 25-26 there's term. Yeah. There's going to be, historically, there's about, let's just call it an even 70 cases that are heard by the United States Supreme Court that they ultimately rule on. It's a lot of oral arguments, that we'll be able to cover the key ones. If you're interested in a guide, Democracy Forward, who's with us here on Legal AF and comes on about once a week to talk about one of their 90 cases they have now against the Trump administration, they just published, and we have up on Legal AF Substack, their guide to the 2025-2026 term. So first, I want to tell you to join our Legal AF Substack. We're now up to over 90,000 subscribers, and kind of top of the charts in U.S. politics. And if you go and you scroll down, you'll see exactly where we have this. Yeah. You'll see the People's Guide to the U.S. Supreme Court, which is up on our Substack, which will give you a good idea of sort of the key cases broken down by subject matter, like immigration, women's rights, reproductive rights, voting rights, election law, presidential power, transgender rights, things like that. So it's a Bible for me as well. So if people are wondering, how do you keep track of all this stuff? It's contributors like Democracy Forward. And they also have a great playlist. You're here on Legal AF, so take a moment, hit the free subscribe button, become a subscriber, set your reminders for shows like this one. We do this every. It's put up for you guys every Saturday morning. We try to do it the second video, and then slide over to. And we have no outside investors, no paywall. It's just subscribe. Now, for those that want to make an investment in Legal AF, so I had a friend of mine write me and say, "How do we invest in Legal AF?" I'm like, "Not that way. we don't take it. I appreciate it. We don't take investors, but we don't. Nothing to compromise our independence. So, but go to Legal AF Substack, where you'll see people like Dina and me and writing. Dina, you're doing some writing now for Legal AF Substack along with your own Substack. Become a paid member there if you can swing it. I kept it cheap. It's like $7 or $8 a month, not a week, and that's for just unparalleled. I almost said unprecedented volume of work there, including live reporting. So if you want to become a card-carrying member of the Legal AF community, becoming a member of the Legal AF Substack is the way to go. So
that sounds great. And just to I also just wrote a Substack on there of just October's big cases. There's so much in October. The first day talks about conversion therapy, whether or not that's free speech or not. And to give people just the quickest primer, not only is that conversion therapy the first case, but you and I are going to have a ton to talk about because the Voting Rights Act is the big October case. The big November case is tariffs. That case goes in front of the Supreme Court. The big December case is whether or not Humphrey's executor is going to live or die. January, we have the Lisa Cook case, and they just added the Second Amendment case today. I mean, there's going to be transgender athletes. There's more and more and more, but that's just the quickest primer just on these. We have at least one big case a month coming here.
Well, what I'd like you to do is offline go over with me and propose to me which cases you think we should put up on Legal AF under the live tab, where we started it later last year, but I want to continue to do it. So give me some suggestions there. We'll work with our team to make sure we get the live up, and then where we can sort of identify who are the people speaking. We usually can do the judges, the advocates. Sometimes they're a little bit harder, but once I know who the advocates are, we'll be able to do that too. So thanks for joining Unprecedented here exclusively on Legal AF YouTube channel. Until next week, it's Michael Popok and Dina Doll. Can't get your fill of Legal AF? Me neither. That's why we formed the Legal AF Substack. Every time we mention something in a hot take, whether it's a court filing or a oral argument, come over to the Substack. You'll find the court filing and the oral argument there, including a daily roundup that I do called, wait for it, Morning AF. What else? All the other contributors from Legal AF are there as well. We got some new reporting. We got interviews. We got ad-free versions of the podcast and hot takes. Where? Legal AF on Substack. Come over now to free subscribe.